We're actually going to start with Mr. Walsh first. We have a private attorney for that. I can't hear you. You can't hear me? Kristen?
Good morning. I'm assuming you're going to go right down the list?
I'm going to try, yes. Does that
Okay,
work?
thank you so much.
Perfect,
Have a
thank
good
you.
day.
You too.
Thank you.
I go to office where your hand, okay?
The what?
I go to off where your hand and it will activate the sensor.
Okay.
Hey, good morning. I am Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning William Walsh, inmate number 183081, and today is Tuesday, December 17th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Carl Robinson Correctional Institution. Can you please state your full name and inmate number for the record?
Yes, it's William Walsh, 183081.
This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Mason and Parole Officer Sullivan. Attorney Mason, can you please identify yourself for the record?
Good morning. My name is Attorney Abigail Mason, and I represent Mr. William Walsh.
And Officer Sullivan, can you please identify yourself for the record?
Parole Officer Sullivan for the Special Management Unit out of Waterbury.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Walsh and Officer Sullivan, can you both please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. So first, I'm going to read you your rights, and then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. Then I'll review and identify the exhibits filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
I know, ma'am.
So you do have important rights for this hearing, and I'm going to review them with you now. The first is you have a right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, ma'am.
You have the right to review the evidence against you before the hearing, and you have the right to submit evidence in support of your case. You also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So now we're going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Sullivan, can you please read for charge number 1, condition of GPS, what you reported?
Charge 1, GPS. On 8/16/2024, you removed the GPS monitoring device from your ankle without permission of your parole officer in violation of your signed GPS monitoring agreement.
And charge number 2, condition of absconder.
On 8/15/2024, you signed out of Bishop Halfway House for work at approximately 1:51 p.m. with an expected return time of 12:30 a.m. on 8/16/2024. You never returned to the halfway house and didn't make contact with your parole officer. You do not have permission to reside in any other residences. Your parole officer made multiple attempts at contacting you via phone with no contact made. Your whereabouts in the community are unknown.
Thank you. Charge number 3, condition of drugs.
On 7/29/2024, you used crack cocaine.
Charge number 4, no consumption of alcoholic beverages.
On 7/28/24, you consumed alcoholic beverages.
Charge number 5, halfway house placement.
On 8/15/24, you signed out of Bishop Halfway House for work at approximately 1:51 p.m. with an expected return time of 12:30 a.m. on 8/16/2024. You never returned to Bishop Halfway House. You do not have permission to reside in any other residences. Your actions violated your halfway house agreement. I will return to the halfway house from community pass at my scheduled time. Isn't there? On 7/27/24, you signed out of Bishop Halfway House for work at 1:23 p.m. with an expected return time of 12:30 a.m. on 7/28/24. You failed to return until 4:45 p.m. on 7/28/24, making your whereabouts unknown for approximately 16 hours. Your actions violated your Halfway House agreement. I will return to the Halfway House from community pass at my scheduled return time.
Thank you. The state has also filed the following exhibits that have been pre-marked for identification purposes. Officer Sullivan, can you please identify the exhibits you submitted?
Exhibit A, remand to actual custody. Exhibit B, parole violation notice and parolee rights. Exhibit C, parole violation report. Exhibit D, signed PCS parole conditions. Exhibit E, Bishop Halfway House agreement. Exhibit F, attentee GPS strap violation. Exhibit G, Bishop Halfway House incident report. Exhibit H, voluntary admission of positive test results. Exhibit I, misconduct reports. Exhibit J, GPS monitoring agreement signed.
Thank you. And in addition, the state did file an addendum to the parole violation report on October 10th, 2024. Officer Sullivan, can you please read the addendum submitted?
I don't think I have the addendum. I don't have the addendum in case notes wasn't working, so I wasn't able to print it out.
Okay, no problem. I'll read it. So it was submitted on October 11th, 2024, and it states in reference to the parole violation report submitted by P.O. Sullivan regarding Walsh Williams number 183081. The following applies. On September 13, 2024, the Board of Parole issued a warrant based on that report declaring the offender an absconder from parole supervision. On September 18, 2024, the case was transferred to the Fugitive Investigation Unit. On October 11, 24, the FIU apprehended Walsh. Mr. Walsh was apprehended at his sister's residence in Torrington, Connecticut. Parole officer Citatello and Lettieri transported him to New Haven Correctional Center without incident. He was served his parole violation notice and parolee rights. The signed notices were scanned into case notes. Mr. Walsh and Attorney Mason, did you both receive the notice of violation? The notice of violation, the parole violation report, and all the other documents that have been identified?
I believe we did. I'm not sure about, I believe we received everything but that addendum.
Yeah, I
Okay.
got everything. I got everything but the addendum.
The addendum. So would you like time to review the addendum? We can continue the case, or are you okay to move forward without it?
I think we're okay to move forward. That
think we're
nothing in there is new to us. Yep.
Okay, perfect. So I also did receive exhibits from the defense. I received Exhibit 1, a letter of support and sponsorship from Marissa Yanglango, and Exhibit 2, records from the Substance Abuse Treatment Center. Are those all the documents that you're submitting today for evidence?
Yes.
So we do not have any witnesses. So at this time, it's the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. Officer Sullivan, would you like to make a statement?
Yeah, I mean, this isn't the first time that this has happened with.
Sorry, Officer Sullivan, are you still there? Officer Sullivan? Ms. Benedict, any thoughts? Did I lose connection? You guys can hear me? Yeah. But
I can
you're-
hear you.
Oh, but you're muted. Okay, Officer Sullivan, are you there?
Hello?
Hi. Hi, Officer Sullivan?
Hi, sorry, I don't know what happened. It said it disconnected.
Oh, no, that's okay. So you're just at the point of making statements concerning the charges. Anything you'd like to say?
I'm not sure what you heard and what you didn't hear. So basically, you know, I know that substance abuse is the #1 issue for Mr. Walsh, because when he's actually, you know, not using, he's doing well, he's working. But once the substance abuse thing kicks in, it's kind of, he's off to the races. He cuts the bracelet and he takes off. So, I mean, we've given him opportunities for treatment. So even when he's in treatment, he still continues to use in the IOP. Thank you.
Thank you. And it's now the defense's opportunity to call any witnesses, present evidence, and speak to the charges, or any of the evidence submitted.
I'll speak to the exhibits that I submitted in the background stage of the hearing.
So you're ready to move forward now?
Yes. Yeah.
Okay. I'm just going to take a moment to review what I have received, and then I will announce my findings. Okay. So on charge #1, I do find that you violated the condition of GPS based on the evidence provided, which is exhibit C, D, F, and J. Charge #2, I find that you violated the condition of absconder based on the evidence submitted, and that's exhibit C, D, and G. For charge #3, I'm making a no finding, as the state failed to provide sufficient evidence that you used cocaine on July 29th, 2024. Charge #4, I do find that you violated the condition of no consumption of alcoholic beverages based on exhibit C, D, H, and I. And for charge #5, I find that you violated the condition of halfway house placement based on exhibits C, D, E, G, and I. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, the state will have opportunity to speak to your background and history. And after the state is finished, the defense will have the same opportunity. So, Officer Sullivan, do you have anything additional that you'd like to add to your statement that you just made?
No, just that I have the voluntary of him saying that he did use crack cocaine, but other than that, no.
Okay, thank you. And Attorney Mason, it is now your opportunity to make a statement regarding your client's violation, background, and history.
Thank you. We're asking that Mr. Walsh's special parole be reinstated as soon as possible. Mr. Walsh is a 53-year-old man who's been in and out of incarceration without having his substance abuse and mental health needs properly met. During this recent release, Mr. Walsh truly thought that he would never be behind bars again. As he's getting older, he's been reflecting on his life and his relationships with his family, and he's not proud of what he's accomplished. He was motivated to engage in treatment this go around and to find work, and he started off in the community achieving both of those goals. He was working as a blow molding technician, and he was attending intensive outpatient treatment at the Wellmore Center. As I said earlier, I submitted information from the Wellmore Center that shows that Mr. Walsh had gone to treatment with a positive mindset and insight into his mental health needs. He had said to the Wellmore Center that his main goal was to be happy. He attended classes and was actively participating in treatment, but unfortunately, the environment that he was living in exposed him to drugs on a daily basis. Despite his history of addiction and witnessing addiction through his mother and his siblings, he believed he could just relapse just once and get back on track. but he relapsed before he fully was able to address those mental health needs according to the plans set forth by the Wellmore Center. He stated that there were discussions with the center that he may need ADHD medication and possibly a medication-based treatment to help with his cravings. But he unfortunately relapsed before he was able to start either of those treatments. He acknowledges that he hasn't had an easy time on supervision, but his addiction needs do need to be addressed. Mr. Walsh felt that the halfway house that he was in exposed him more to others who were not as dedicated to as he was to their sobriety at this time. The house he was also in was back in an area where he's lived before, and he knew where he could feed those cravings. Mr. Walsh, in support of his request for another chance to prove himself, to prove that he's serious about his sobriety, has presented an alternative living situation. Prior to his relapse, he met a woman who has offered to house him and sponsor him. I submitted that letter from her in my materials, and I believe that living in a home that's not surrounded by others struggling with addiction, that's isolated in Torrington and not back at his old stomping grounds, Mr. Walsh will be able to avoid these triggers. He does wish to return back to IOP and will address whatever he needs to make things right this time around. And he'll also immediately go to an employment agency to try to get back to work so he doesn't have idle hands. Mr. Walsh has expressed to me that this plan and the idea of kind of moving forward in this direction will make him happy, which was one of his goals in sobriety, and he's optimistic about maintaining it. Thus, we're asking the Board of Pardons and Paroles to allow his special parole to be reinstated as soon as possible so he can re-engage with the progress that he's made and surround himself with like-minded people who want to be better.
Thank you.
I believe Mr. Walsh also wants to say something briefly.
Absolutely. Go ahead, Mr. Walsh.
Good morning. I've always heard about the stigma placed upon addicts and, of course, criminals, but I've always lived up to that stigma. I've always relapsed. I've always come back and forth to jail, with no fault at all but my own. But when I went to this Bishop house, I was doomed from the beginning, and I didn't realize what I was getting into. It's nobody's fault. Parole, nobody knows what goes on there, really. But when I got there, the day I got there, I was offered any type of substance I wanted, and I fought it for 30 days, almost 30 days, and I couldn't say no. And there's no fault in mine. But the thing is, all I ever wanted was, well said, Ms. Mason. I've always wanted to be happy, and but there's actually no excuse for what I've done besides. I'm asking you to be the catalyst to help me get back to my feet, to let me prove myself by not being in that environment. But regardless of the situation, the environment I'm in, it doesn't matter where I go because the mentality is still there, and if I want to use, I'm going to use. But how many times am I going to say that, I have the opportunity again, possibly. I don't care, whatever it takes. It's going to get done. I'm going to do it. I'm going to strive for it. I'm going to be more diligent about it. The last thing is about the Wellmore Center. The day before I absconded, I had my mental health evaluation done, and he's prescribed this medication called baclofen, and it cures alcohol and cocaine cravings, and they swear by it. And I've been asking guys in here about it, and they said absolutely it works. So I got prescribed that he said I had. This is the first time in my life I've ever been to a mental health physician. That's why I was trying to find out what's going on. Why do I think like this? So he gave me the prescription. I never picked it up. So I am eager and willing to try this. I'm going to get right on it as soon as I get back out and give it a shot. And let's pray to God that it works. Because if it doesn't, the last thing that's gonna happen, the only thing I'm gonna get out of this is jails, institutions, or death. That's the only thing I'm gonna get out of using drugs. Thank you.
No, thank you. I do have just a few questions. So when you left the halfway house and absconded, that's when you stopped treatment as well? You discontinued working with Wellmore?
I didn't have any dirty urines. I had, when I had left there, I didn't go there high. I refused to because I was embarrassed and I was ashamed. And because I was very, I participated every day. Every time I went there, I spoke highly. I loved it. And I even after I absconded, I was getting calls from them telling me to come back.
That's what I was wondering, because I read the report. It sounds like you were doing very well there, but I was just wondering, coincide when you absconded, you stopped reporting there as well, correct?
Yeah, yes, because
Okay.
I was ashamed. Yes.
Okay. But my understanding, what you said to me today, is that you're planning to go back to them?
Yes, absolutely. I would love to go back there and get back to right where I left off. Absolutely. I enjoyed those classes.
Yeah. Well, like I said, I did read the report. It sounded like you were doing very well in them. But I did hear what Officer Sullivan stated, where when you relapse, it's just done at that point, unfortunately.
Can I speak on that?
Sure.
When I get high on cocaine, all bets are off. I get instantly, I'm sure you guys know the side effects, but you get paranoid, schizophrenic, and delusional. And I was all that, and I didn't want to go back. I was scared. I didn't have the I didn't have the power to go back. And you get the efforts. You really do. You get the efforts big time. And but I'm so tired, Mr. Trusello. I'm so tired. I'm tired. I'm tired of running. I'm tired of doing this, coming in and out. My family's tired. My kids are tired. My grandkids are tired. But most of all, I'm tired. Because the first thing that you lose when you use is your self-respect. And once that goes, who cares, right? So, all right, thank you.
No, thank you. I do appreciate your comments and your statements. I'm just going to take a moment, then I will let you know my recommendation.
Okay.
Okay. Just want to check his record 1 second. So I have listened to testimony and I've reviewed all of the evidence submitted as well. I am going to recommend that your parole is revoked and you serve an approximate 6-month sanction as with a re-parole date of April 11th, 2025. In addition to my recommended sanction, I'm also going to recommend the following conditions: no alcoholic beverage consumption, no contact with your co-defendant Patricia Northrop and Joshua Habib, no contact with minors without your PO's permission, a problem sexual behavior treatment. I know you did propose a sponsor and I will submit it to Parole and Community Services, but as you know, it's ultimately up to them. So I'm also just going to add the halfway house stipulation just in case if whatever they decide. So that does conclude this hearing. I'm going to forward my recommendation to the board on, it's January 2nd. Sorry, 1 second. Yep, January 2nd, 2025. And you'll receive a written notice from them shortly after that date. The board can lessen my sanction. They can also let my recommended sanction stand, or they can impose a sanction longer than what I've recommended. If they want to impose a sanction longer than what I've recommended, you'll receive that in writing as to why and what they're going to address with you, and it'll be present for that hearing, okay? Do you have any questions at this point, Mr. Walsh?
No, ma'am. No, ma'am.
Then this does conclude the revocation hearing, and I'm going to go off the record. Thank you, everyone.
Thank you.
Thank you.
Take care, Mr. Walsh.
Take care. Thank you.
Thank you. Hi, Ms. Jones.
Good morning.
Good morning. April. Officer McCue, are you with us? I think I have to call her. Hold on one second.
They calling you.
Oh, I didn't call him. Are you Mr. Brooks?
No, that's what you want?
Yeah.
Hi,
Hi, can we have Mr. Brooks next, actually?
Brooks, okay.
Yeah, please, thank you.
We're discussing that. Good morning.
Good morning, I'll be right with you, okay, Mr. Brooks?
All right.
Good morning.
Good morning.
Hi, Officer McCue, are you with us? Officer McCue, can you unmute, please?
If you can try again, press *6.
Miss Benedict, what is it, stars? What is it?
*6.
Officer McCue, can you press *6 to unmute, please? Miss Benedict, what should I do? Come on in. I mean, do they actually? Officer McCue, can you press *6? There she goes. What do you think now? Sorry, we're gonna try one more time.
Would it be helpful to you if I just come back? I have the only 9:30 hearing with Officer Saunders. So I don't know if that would be helpful, and then perhaps Officer McCue can figure out her issues.
Yeah, if that works. Well, I would
I
need
just don't-
Attorney
I
Teen. I
just
feel
don't-
like I saw her.
What's that?
I haven't, see if she's here. I didn't realize you guys had the time.
Yeah, I just don't want to back her up, so I'm just making a suggestion. You let me know what you want to do.
Officer McCue, can you unmute, please, with *6? Hey. Are you there,
Hello?
Officer McCue?
Yeah, I'm sorry. That was super weird.
That's okay. Attorney Jones, do you want to keep going forward, or is it
Yeah,
better
that's
for
fine.
you? Are you
Now that
sure?
we're here,
Okay.
yes. I just didn't know
Okay.
how long that was going to take. Thank you.
No, that's fine. I understand. Thank you. So good morning. I'm Parole Officer Tyrelle. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Shalik Brooks, inmate number 341751. Today is Tuesday, December 17, 2024, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Can you please state your full name and inmate number for the record?
Shalik Brooks, inmate number 341751.
This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Jones and Parole Officer McCue. Attorney Jones, can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Brooks.
Thank you. And Officer McCue, can you please identify yourself for the record?
Hi, good morning, Parole Officer McCue, Hartford Parole.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. The testimony on today's hearing will be taken under oath. So Mr. Brooks and Officer McCue, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
Yes, ma'am.
Yes, I swear.
Thank you. So first I'm going to read you your rights, and then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. The state will then have the opportunity to present any relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have the opportunity to speak to your background and history. After the state is finished, you'll have the same opportunity. Do you have any questions about the purpose or procedure?
No, ma'am.
Perfect. So we're going to go over the rights that you have for this hearing. The first is you have the right to be represented by an attorney at this hearing and counsel's present. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
Do you have the right to review the evidence against you before the hearing? And you have the right to submit evidence in support of your case. And you have the right to call and examine any voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're going to review the charges that the state, your parole officer, has brought against you and the information underlying each charge. Officer McCue, can you please read the charges that you have submitted against Mr. Brooks?
Sure. Just to be clear, the phone keeps kind of beeping or coming across as beeping, so if I need to repeat myself, just feel free to interrupt me and let me know.
Okay, thank you.
Yep. First charge is obedience to the law. On July 22nd, 2024, you turned yourself into Manchester PD in an active warrant for Connecticut General Statute 53A-117, criminal mischief in third degree, and 53A-182, disorderly conduct. You were given a court date of July 23rd, 2024 out of Manchester JA-12 on docket H12M-CR24-0296168-F. This warrant is a result of your accused behavior of damaging property of another party at their residence on July 10th of 2024.
Thank you. The state has also filed the following exhibits that they pre-marked for identification purposes. Officer McCue, can you please read the exhibits you've submitted?
Exhibit A is conditions of parole. Exhibit B is notice of parole violation. Exhibit C is parole violation report. Exhibit D is remand to actual custody. Exhibit E is state of Connecticut arrest warrant application. Exhibit F is state of Connecticut judicial branch pending case detail. Exhibit G is parole violation report in parentheses from a previous violation. And Exhibit H, decision information summary.
Thank you. And in addition, the state has filed an addendum to the parole violation report on November 22nd, 2024. I also am identifying the new evidence that she submitted, which was a case in charge information sheet as Exhibit I. And then in addition, the state did file an addendum to the parole violation report on November 22nd, 2024. And Officer McCue, can you please read the addendum you submitted?
Sure. November 22nd, 2024. So on November 20th, 2024, Shalik Brooks, inmate number 341751. Case was heard out of Rockville Court, GA _ on docket H 12M-CR24-02966168-S. And he entered a plea of not guilty on the following charges: 53A-117 criminal mischief third and 53A-182 disorderly conduct. Both of these charges were nollied and supporting documentation was uploaded into case notes.
Thank you. Attorney Jones, did you and your client both receive the notice of parole violation report, and all the other documents that have been identified?
No, I don't have document I that you just referred to and remarked. What is that document?
She's, Officer McCue submitted a case and charge information sheet from the judicial, from CJIS showing the dispositions of the case. Was that not a part of the addendum we sent you?
Okay, I don't actually have that exhibit. I have the addendum, but I don't have that exhibit.
Would you like me to forward it to you?
That would be fine, just so I have it for my record. It should not affect my ability to go forward. I would just ask that, yes, if you wouldn't mind at some point in time, yeah, that would be, I would appreciate that. And
like I said, it's just the disposition sheet showing the nollies for the two charges. But I'll send it to you when I get a second.
Okay, I appreciate that. And just for clarification purposes, this matter, I don't believe, was heard in Rockville Court. I believe this matter was heard in the Manchester jurisdiction, GA12. That's evidenced by Exhibit 3, the transcript that I submitted that does indicate that it was heard GA12 at Manchester. So for clarification purposes, I would just note that.
Thank you. Okay. So are we okay to move forward at this point of the hearing?
Yes.
Okay, perfect. I will make note to send this to. Okay, in addition, I have received exhibits from the defense, and that is identified as Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, an email from Daquana Blake. And Exhibit 3, a transcript from 11/20/2024 Manchester Superior Court Proceedings, State versus Shalik Brooks, H12M-CR24-0296168S. Do you need any more additional time, Attorney Jones, to submit any additional evidence?
No, I do not.
So today we have no witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to the evidence submitted. Parole Officer McCue, would you like to testify towards the charges?
No, the evidence speaks for itself.
Okay, thank you. And at this time, it's the defense's opportunity to call any witnesses, present evidence, and speak to the charge and any of the evidence submitted.
Thank you very much. In regards to the sole charge, charge 1, obedience to the law, we would ask that you make a no finding of preponderance of the evidence based on the fact that, number 1, on November 20th of 2024, my client did appear in GA12 Manchester. Both counts were nollied. The transcript does reflect at that time that the victim's advocate conveyed that the alleged victim did not want to pursue the charges and was not looking for restitution. And I would just point out the strength of the state's case as evidenced by, number 1, the transcript, the police report, where this individual gave a statement to the police saying that my client broke a window. However, she also indicated that she did not observe him break a window. She just knew that it was him. In addition to that, my client, when he spoke to the police, told the police, denied the allegations, and then explained to the police that this alleged victim has cameras in her home and that they could view those cameras to see what in fact actually took place. When the police went to talk to her in regards to viewing those cameras, she acknowledged, yes, she had cameras in her home, but that she did not have access to those cameras. I would just submit to you that that does not make any sense, that an individual would have cameras within their home, but not have access to the cameras within their home. Again, I would also point out that we submitted an email that she sent to my office, verified by my investigator, with her identification attached, and I will just refer to her as DB just for hearing purposes. That's Exhibit 2, where she acknowledges that she fabricated this information in an effort, basically because she was upset and angry that my client was not looking to be in a relationship with her. She acknowledges that. She gives some excuses for why, and in addition to that, for why she would have also fabricated that information. But she nonetheless admits that she fabricated the information. My client was always cooperative. He turned himself in as soon as this warrant was active. So at this point, we would be, based on all of the information submitted, asking that there be a no finding on this charge. Thank you.
Thank you. So I'm just going to take a moment to review the evidence submitted, as long as no additional comments want to be made. Is that correct? Officer McCue, any other statements?
No other statements. Thank you.
Attorney Jones?
Not at this time.
Thank you. So for charge number 1, I am going to find that you violated the condition of obedience to the law based on the evidence submitted with Exhibit A, C, and E. Because although the court nollied the charges, there's behavior that occurred on that date at some point. So I am going to make a finding for the charge. So at this point, it is the that concludes the fact-finding portion of the hearing. Before I make my recommendation, the state's going to have an opportunity to speak to your background and history, and after the state is finished, you'll have the same opportunity. So, Officer McCue, do you have any comments towards Mr. Brooks' violation, background, and history at this point?
I do. I just kind of want to make a quick statement on behalf of it. So in the situation itself, Mr. Brooks did not have permission to communicate with the other person involved in this case. That was more the concerning behavior. I am in support of what the attorney is saying, and that the whole situation seemed very inappropriate for what actually transpired. We just want to make sure that Mr. Brooks is following his conditions of parole and that he is safe and being supported in the community as well.
Thank you. And Attorney Jones, it is now your opportunity.
Thank you. My client's 33 years of age. He's single. He does have 6 children. They all reside in Connecticut. He has a strong family support system in the community, including his mother, who he most recently sponsored to in Suffield, Connecticut. He does not have any mental health or substance abuse issues. He does have a serious medical condition, and that he does live presently with 1 kidney due to being the victim of gun violence, where he was the victim of an attempted robbery while his mother was present. He's been in the community for approximately 4 months since being reparoled on March 7th of 2024. And during this time period in the community, he's been gainfully employed working at Home Goods in Glastonbury as a selector. In addition to that employment, also working at the Target warehouse in Windsor as a selector. Again, as I previously indicated, he was sponsored by his mother in Suffield, Connecticut. And as a result of being the victim of gun violence, my client began and was participating in private individual counseling, which took place in person and via video conference. He reports attending this counseling once weekly from November of 2022 until recently, until he was remanded. While he's been in the Department of Corrections during this time period, which I believe has, beginning in December, he's been employed as a tierman at Robinson Correctional Institution. Lastly, my client's been incarcerated for approximately 5 months on this remand based on a case where the alleged victim admitted to lying. I understand that you made a finding here. I respectfully disagree with that finding. She told the police initially she didn't She didn't witness my client do anything, break a window, but she just knew it was him. She had cameras in her home, but claimed she had no access to them. My client's eager to return to the community, get back to work. He's always been working. He's always been supporting his children. He's eager to get back to supporting his children, both financially, emotionally, being there for him. We would request that he be reparoled at the next available date. He's asking to be sponsored in the Waterbury jurisdiction. He has his employment at Target to return to. He does have his driver's license and a motor vehicle that's registered and insured that he can, that will bring him back and forth to work. So we would be asking that he be reparoled at the next available date. Thank you.
Thank you. I'm just going to take a moment, look at Mr. Brooks' record, and I'll let you know my recommendation.
Can I just ask you a question? When you're saying look at his record, can I ask you what you're referring to?
We're allowed to look back at like prior successes, failures, and like communities.
Yeah, but so what document are you referring to when you are saying that?
His DIS, everything that's on the case notes, we're allowed to look into.
Okay, so can I just make it, place it on the record, and then I'll talk to your supervisor Muniz. We did have a meeting in regards to clients' records being placed into consideration at these hearings, and we were told that we would be given a copy of whatever it is that you are going to be considering when you're looking at their records, whether that be a CSBI or whatever the document is. And I will just place on the record that I don't have the document that you are looking at now when you're saying that you're looking at his record. And so going forward, I think that as part of the discovery process and us being able to make comments to that record, that we should be given a copy of that. And we were told that we would be given a copy of that. Just wanted to make that clear, and I will proceed with the necessary communication after this to make sure that happens. Thank you.
Absolutely. Absolutely. Thank you.
Hey, Con, I just want to interject. I apologize. So just to be clear, I might be misunderstanding, but I think the only reference that we would be able to use and be appropriate in this is the decision information summary that was already included in his evidence packet. So you hopefully should have that. You should have the whole evidence packet. There shouldn't be anything in addition to that.
She is correct that the DIS was submitted, but we're allowed to look at like the RTs and stuff like that.
No,
so
no.
yeah, I agree.
I just wanted to make sure that she did have that.
No, that's not what I'm referencing, but I appreciate the comment. I'm referencing I'm assuming that you're referencing his past criminal history, inclusive of any prior violations. I do not have a copy of the information that you're referring to right now and that you're looking at when you're considering his sanction. And I was told that our office would be given a copy of that prior to the hearings.
Yeah, I was not aware of that.
Yes, yeah. Thank you.
No, yeah, I really understand, Attorney Jones. I was not aware that that was something. However, I do see that she was in the DIS. I do just have a question. Mr. Brooks, do you and the victim DB have children together?
Yeah, we have a 2-year-old son together.
You have a 2-year-old son? Okay.
And yeah, so I did want to address, I understand the PO was recommending a strict no contact. And my request would be that be a no contact without the PO's permission, based on the fact that they do share a child, and there could be family court orders. I'm not entirely sure about what orders are in place out of the family court. But I certainly would want my client to be able to comply with any orders, and therefore I think it would be appropriate that he be allowed to ask his parole officer for permission if he needed to have contact with her, to facilitate contact with his child and comply with any orders that may exist out of the family court.
I agree. I'm still, so my issue is there was a general no contact already with someone with a DB initials before. But on that agreement that he signed, it said Jaquana Brooks. I'm understanding that this victim is someone new, or is this the same person?
No, that is the same individual, is my understanding.
That's what I was kind of confused. Go ahead, Officer McCue.
No, I'm just confirming it's the same person. It's not a new victim in this situation.
So is her last name Brooks, or is it something else?
Oh, it's not Brooks.
No, it's not Brooks.
No.
What is it?
It's Blake,
Blake.
correct?
Yes.
Okay, because
was
like I
incorrect.
said, my documents from the last time is that it was a different last name.
Yes.
So I do understand that they do have a child together. That's why I just want to confirm that too. So I am going to recommend that Mr. Brooks' parole be revoked and that he serves an approximate 5.5 month sanction with a re-parole date of January 2nd, 2025, which is the board review date. In addition to that recommendation, I'm going to recommend the following conditions: no alcoholic beverage consumption, behavioral management program for domestic violence, no contact with the co-defendants William Cole and Jonathan Moret, no contact with victims G, C, and DH and HW, a general no contact with DB, be it for Blake, without parole officer's permission, in no operation of a motor vehicle without parole officer's permission. And I did read in the evidence submitted halfway house placement in Waterbury, correct?
Yes.
Yes.
So those are my recommendations. I am going to submit them to the board, like I said, on January 2nd, 2025, which is the re-parole date that I am recommending. And at that date, the board can lessen, well, they can't lessen it. They can take my recommendation, let it stand, or if they want to impose a sanction longer than I've recommended, a supplemental hearing can be held, and you'll be notified of that with the reasons why, and you'll be present for that to address their concerns, okay? Do you have any questions right now, Mr. Brooks?
No, ma'am.
Okay, then we are all set. This does conclude the revocation hearing, and I'm going off the record.
Thank
Thank
you.
you, Sonia. Appreciate you.
Yep. Good luck, sir.
Thank you, everybody. Thank you, Officer McCue and Attorney Jones.
Thank you.
Thank you. Have a good day.
Too. Maybe please see Camacho now?
Okay.
Thank you.
You're welcome.
Officer Ball, are you here?
I am. Good morning.
Perfect. Good morning. I'm just going to go grab his attorney. I'll be right back.
Okay, thanks. Morning, Alex.
Morning.
Okay. Good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Alexander Camacho, inmate number 314162. Today is Tuesday, December 17, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Carl Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Alexander Camacho, 314162.
Thank you. This is a hearing, public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Dean and Parole Officer Ball. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean from the Public Defender's Office on behalf of Mr. Camacho. Good morning, sir.
And Officer Ball, can you please identify yourself for the record?
Hi, good morning. Parole Officer Ball, Norwich Parole.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, have the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you've been referred to the Department of Corrections for diversion for substance abuse programming and treatment. And if by the end of the hearing I determine that you should be held in prison pending further proceedings, I will provide additional information about the diversion program. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. The testimony at today's hearing will be taken under oath. So Mr. Camacho and Officer Ball, can you both please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. Do you understand, Mr. Camacho? Thank you. So first, I'm going to read you, we're going to go over the procedure for the hearing. So first, I'm going to read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I'll review and identify the exhibits filed for the record. The state will have an opportunity to then address the issue of probable cause and severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
I don't.
So we're going to go over the rights that you have for this hearing. The first is that you have the right to be represented by an attorney, and counsel is here for you. You have the right to receive a written notice of the charges of violation. Did you receive the written notice?
Yes, I did.
You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. In addition, you also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do.
So we're going to review the charges that the state, your parole officer, has brought against you and the underlying information for each charge. So Officer Ball, can you please read for charge number 1, drugs, the violation details?
Yep. On 11/14/24, you submitted a urine sample that returned from Premier Biotech Lab positive for cocaine. You denied use. On 11/26/24, you signed a voluntary admission for cocaine use or to cocaine use on the previous night.
Right. And Officer Ball, can you please identify and read the list of exhibits that you submitted for evidence?
Yep. Exhibit A is parole violation notice. Exhibit B would be the remand to custody. Exhibit C, parole violation report. Exhibit D, signed parole conditions. Exhibit E is the Premier Biotech Lab results from 11/14/24 sample. And Exhibit F would be the voluntary admission signed on 11/26/24.
Thank you. Attorney Dean, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have.
Thank you. I have not received any evidence from the defense. Is that accurate?
Accurate, yes.
Are you ready to move forward without?
Yes, we are.
Perfect. So today we do not have any witnesses. So at this time, it is the state's opportunity to make a short statement calling witnesses and testify with respect to probable cause and the severity of the allegations. Officer Ball, do you have any comments to make towards the charge?
I just want to say I've supervised Mr. Camacho for many, many years. He's done very well with me for many years. Unfortunately, when he uses cocaine, he suffers from paranoia and delusional behavior. So my hope is just that he goes to the TAP program, he hits a reset, and he comes back out and starts over. He does do well while he's out in the community, and we just need to keep him clean.
Thank you. And Attorney Dean.
This time, since this is a recommendation to the diversionary program, we'll be conceding the probable cause portion of the hearing. Thank you.
Thank you. So I am just going to make a finding that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you wait for your revocation hearing. And at this time, the Department of Corrections has recommended you for the diversion from the revocation process. Just want to check one thing. So what that means is that if you wish to participate, Mr. Camacho, and I find that you meet the criteria, the eligibility criteria, I can continue your case while you're provided the opportunity to participate in the TOP program in the correctional facility. And then if you successfully complete the program and treatment provided, I will dismiss your case and order your parole reinstatement. And if you do not complete the program and treatment provided, the board will then schedule you a revocation hearing to determine if you did violate the conditions of your parole. The decision to participate in the diversion is voluntary. And do you understand the diversion process? And do you wish to apply?
No, I don't.
You don't want to apply?
I mean, apply for what? I'm kind of confused.
Oh, sorry. Okay.
Sorry.
Go ahead.
So, Mr. Camacho, when you and I spoke last week, we had discussed that you were being recommended for a diversionary program for this. So instead of being placed, automatically, being taken to a revocation hearing. They're giving you the chance to complete this inpatient, basically it's in the facility, this treatment. And then if you successfully do that, at that point, you could be reinstated back on your parole. So she's just asking, do you want to do that program while you're in to potentially get the benefit of that?
Yeah, with the top program?
Yeah. Yes.
Yeah.
Okay, great.
So we're going to go over now the eligibility and determine if you are eligible, and then I'll accept your application and then divert you from revocation. So I do find that you do not have any pending misdemeanors or felony charges. I also find that your discharge date is more than 60 business days from the date of your remand to actual custody. I do find that there's evidence that you have identified substance abuse treatment needs. I also find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms of your condition on parole. And I also find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming or treatment during the period of your parole supervision in the community. So with that being said, I do determine that you are eligible for the diversion program for substance abuse programming and treatment, which is the top program. But before I accept your application for the diversion, I need you to indicate whether you understand the following by answering yes or no. The first is, I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result. You understand?
So my question, I got a question. My question is, do I got to go to another hearing after today, or just after finish the top program?
If you successfully complete the top program, then that should not be necessary.
All right, I got it.
So the next statement is, I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes.
So that's what you were asking, just to confirm. So if you don't, it can lead to revocation, but as long as you complete the top program successfully, we'll be notified by your parole officer to send a release, okay?
Okay.
All right. The next statement is, I understand that ultimately the Department of Corrections will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes.
And I understand that my participation in this process is completely voluntary.
Yes.
Perfect. So your application for diversion is granted. You will be placed in treatment and top if you haven't already. I'm assuming you might have already started.
No, I started already.
Perfect. And that will divert you from revocation for no more than 60 business days, okay? Do you have any questions at this point, Mr. Camacho?
Nope.
Okay, thank you. So this does conclude the preliminary, and I'm going off the record. All right, you're all set, Mr. Camacho. Good luck, okay?
Okay, bye, Ms. Ball.
Thank you.
Bye, Alex. See you
Bye,
soon.
y'all have a good day.
Good
Have a
luck.
good
Happy
day.
holidays.
Thank you, everybody.
Thank you.
Good morning.
Good morning.
Good
Good
morning.
morning. All right, so good morning. I'm Parole Officer Trissello. I don't think we have any POs today, right? No. Okay, good. So I am a hearing examiner for the Board of Pardons and Paroles, and this is a revocation hearing concerning Ivan Rhone, inmate number 265939. Today is Tuesday, December 17th, 2024, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Carl Robinson Correctional Institution. Can you please state your full name and inmate number for the record?
Ivan Rhone, 265939.
This is a public hearing, and public access to this hearing is available via video live streams. Present this morning is also Attorney Famiglietti. Can you please identify yourself for the record?
Good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you, and the state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support the violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Rhone, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for the hearing at this point. The first is I'm going to read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. I will then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you violated one or more of the conditions of your parole, you will have the opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Great. So you do have important rights for this hearing, and I'm going to review them with you now. The first is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
Right. You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of the case. In addition, at this hearing, you have the right to call and examine voluntary witnesses and to cross-examine any adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're going to go over the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of obedience to law, the charging officer reported that on April 6, 2024, you physically assaulted your 60-year-old father. You struck him in the face multiple times with a closed fist and attempted to stab him with a pocket knife. As a result of your actions, you were arrested and charged with violation of Connecticut General Statute 53A-61A, assault in the 3rd degree of an elderly person, and 53A-49/53A-60B, criminal attempt assault in the 2nd degree of an elderly person. On May 31st, 2024, you appeared in Hartford Superior Court, GA 14, at which time you pled guilty to 53A-61, assault 3rd, and sentenced to 6 months of jail. On April 9th, 2024, CSP and West Hartford PD attempted to detain you on outstanding warrants. You attempted to struggle with officers in the effort to flee. After a brief struggle, officers were able to secure you in handcuffs and inform you of the outstanding warrant. Officers attempted to conduct a search of your person instant to arrest. However, you began to pull away and interfering with their ability to check you for weapons or contraband. You began yelling and dropped your body to the ground, forcing officers to pull you back to your feet. You continued to yell profanities and pretend that you were choking. Once officers gained compliance and able to conduct a search of your person, found in your possession was a small bag containing 1.26 grams of MDMA, which was a purple powder substance, a tied-off piece of a rubber glove containing 3 cell phone SIMs cards, and $714 in U.S. currency. Located in the center console of the vehicle you were observed operating was tied-off sandwich bags containing 32 bags of suspected fentanyl, 2 bags containing 4.01 and 0.37 grams of suspected cocaine, 1 bag containing 3.9 grams of suspected crack cocaine, and an additional $10 in U.S. currency. All suspected substances were later tested and yielded presumptive positive results. On condition number 2, on charge number 2, condition of drugs, the charging officer reported that on April 9, 2024, you were in possession of a small bag containing 1.26 grams of MDMA, which was a purple powder substance. Located in the center console of your vehicle, the vehicle you were observed operating was a tied-off sandwich bag containing 32 bags of suspected fentanyl, 2 bags containing 4.01 and 0.37 grams of suspected cocaine, 1 bag containing 3.9 grams of suspected crack cocaine, and an additional $10 in U.S. currency. All suspected substances were later tested and yielded presumptive positive results. The state has filed the following exhibits, which I have remarked for identification purposes. So I have Exhibit A, the parole violation report, Exhibit B, conditions of parole, Exhibit C, the Connecticut Superior Court information sheet, Hartford Police Department case 24-8651, Exhibit D, the Connecticut Superior Court arrest warrant application, Hartford Police Department case number 24-8651, Exhibit E, the Connecticut Judicial Branch Criminal / Motor Vehicle Conviction Case Detail Docket Number H14HCR 2407637775S. Exhibit F is the Connecticut Superior Court Information Sheet CT State Police -SNTF NC Office Case Number 24001400407. Exhibit G is the Connecticut Court arrest warrant application, CT State Police SNTF NC Office Case Number 24001400407. Exhibit H is the Connecticut Judicial Branch Pending Case Detail, Docket Number H14H CR 2407647711S. Exhibit I is the remand to custody order, and Exhibit J is a notice of parole violation. In addition, the state has filed an addendum to the parole violation report on November 15, 2024, and is admitted into evidence and reads as followed. On October 30th, 2024, Rhone appeared in the Hartford Superior Court under docket number H14H CR 2407647711S for the following charges: 21A-277A, possession with intent to sell, 3 counts; 21A-277B, possession with intent to sell a controlled substance, 1 count; 21A-279A, possession of a controlled substance, 4 counts; and 53A-167A, interfering with an officer, 1 count. At the time, Rhone pled guilty to 1 count, 21A-277A, possession with intent to sell narcotics, and was sentenced to 5 years jail, 6 months suspended, and 3 years probation. The additional charges of 21A-277A, possession with intent to sell narcotics, 2 counts; 21A-277B, possession with intent to sell a controlled substance; 21A-279A, possession of a controlled substance, 4 counts; and 53A-167A, interfering with an officer, 1 count, were nollied. Attorney Famiglietti, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have.
Perfect. In addition, I have received the defense's exhibits. I received Exhibit 1, a list of parole accomplishments and plans for future parole reinstatement. Do you and your client need any additional time to submit other evidence?
No, we do not.
So today we have no. So, you're okay, Mr. Rhone?
Okay. Yes, okay. Go ahead, finish.
Okay. So today we do not have any witnesses, so it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges of the evidence submitted.
There's no comment as to the preponderance standard regarding charge 1 or charge 2 as a result of the convictions.
Sorry. Okay, hung up on them. Sorry, so can you just repeat that?
Yes, he was convicted of the assault and he was convicted of the possession with intent to sell. So I have no comment as to the preponderance standard as to charge 1 and 2.
Thank you. Okay, so at this time I am going to announce my findings. I have identified charge number 1, condition of obedience to law, as 2 parts, just for support purposes. So with regards to part 1, with the charge date of 4/6/2024, I do find that you violated the condition based on the evidence submitted, which is Exhibit A, B, G, and E. On charge number 1, part 2, and that one's with the charge date of April 9th, 2024. I do find that you violated the condition of obedience to law based on your conviction of the possession with intent to sell, which is Connecticut General Statute 21A-277A, on October 30th, 2024, when you were given a sentence of 5 years jail, 6 months to serve, followed by 3 years of probation. In addition, the following evidence also supports that charge, which is Exhibit A, B, and G. And for charge number 2, I do find that you violated the condition of drugs based on the evidence in support of the charge, which is states Exhibit A, B, and G. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, you will have the opportunity to speak to your violation, the background, and history. So counsel, would you like to make a statement?
Yes. I'd like to start by stating that my client has not been released since April 9th of 2024. He served approximately 8 months so far. His sentence, the 6-month split sentence, is up on April 25th, 2025. Were he to have to serve 100% of it, it's not an 85% crime, it's a 50% crime. So we'd ask for a release prior to 4/25/25, and he would be able to apply for TS for that crime. The PO is recommending a total revoke, which I think is completely inappropriate in this sort of circumstances. His sentence end is 2/20/28. That would amount to a 4-year sentence, and I think that would be entirely inappropriate here. My client is accomplished. He's a single 43-year-old man. He has one son, age 26, that resides in Hartford. 2 months prior to remand, his fiance suffered a brain aneurysm, so that has been on his mind. It's been a significant stressor for him. His primary source of support is his fiance of Hartford and his sister. In the past, he's completed 1 year of the business management program at Ashford Community College. He has an excellent work history. He's worked at Butler Landscaping, Aldi Distribution Center, Waste Management Company. He's operated a forklift at Avon Mountain. He's worked at Salute for 8 months in Hartford, and he's also worked in the home care field on call. He has established primary care services through Hartford Hospital, and his history includes a tumor on his pancreas. My client participated while at Osborn in individual therapy once every 2 weeks or as needed. He's waiting to restart that individual therapy at Robinson. He completed the Voices program beginning of December of 2024, and he participates in the TCM program through Wheeler Clinic. My client, upon reinstatement, wishes to be placed in a halfway house in Waterbury. He wishes to obtain a home care certification. He can return to the seasonal position with Butler Landscaping, and also has a work employment opportunity at Amazon through a friend that is there. Once again, my client is 43 years of age. I don't see this as a sufficiently serious enough violation to have him held more than the 8 months he's already been held. I don't see any other reason other than punitive to keep him in the jail at this time. I think it's appropriate to reintegrate him into the society. Thank you for your time and consideration.
Thank you. So I'm just going to take a moment to review a few things that have been submitted, his record, and I will get back to you with my recommendation.
I'd just like to echo what Attorney Jones said earlier,
Absolutely.
that if you do refer to anything that it was not submitted as evidence to the defense team, that in the future that we have an opportunity to be provided with that documentation. Thank you.
Absolutely, and it's noted. Thank you so much. So I have listened to the testimony today, and I've reviewed evidence submitted as well as just a review of his record at this point. I am going to recommend that your parole be revoked and you serve an approximate 1 year and 2 week period of confinement as a sanction with the re-parole date of April 25th, 2025, which is the end of your new conviction. In addition to that recommendation, recommendation, I'm going to recommend the following conditions: no contact with the co-defendants Alfonso Johnson, Robert Cooper, and Sherrod Collier, no operation of a motor vehicle without your parole officer's permission, a general no contact with JR without your parole officer's permission, and I did no halfway house and Waterbury as first choice, correct?
Yeah.
Okay, perfect. So those are my recommendations, and they're going to be forwarded to the board on January 2nd, 2025, and you'll receive a written notice from the board shortly after that date. If the board chooses to lessen my sanction, or at that hearing, they can choose to lessen my sanction, they can let my recommended sanction stand, or they can impose a sanction longer than what I've recommended. If the board decides to impose a sanction longer than what I've recommended, you'll receive notice of the supplemental hearing as to why, and you'll also be present to address their concerns. Do you have any questions at this point, Mr. Rhone?
No.
Okay.
No, thank you very much for your time and
So
consideration.
this does conclude the revocation hearing, and I'm going off the record. Thank
Sir,
you.
reach out and call me if you have any questions, okay, sir?
Okay, thank you very much.
You're welcome. Have a good day, sir.
Have a good day.
Thank you.
Thank you. I think I'm all set with you.
Okay, thank you.
Thank you. Have a good day.
You too. Bye.
Here.
Sorry, I had to find it.
You're good.
Hello.
Thank you. Hello. Let me start this.
Yeah, I was in the wrong area. Sorry about that.
That's okay. You are Mr. Byrnes, right?
Yes.
Okay, good. All right, so good morning. I'm Parole Officer Trisella, and I'm the hearing
Good morning.
examiner for the Board of Pardons and Paroles. This is your revocation hearing, and it's concerning you, Myles Byrnes, inmate number 416701. Today is Tuesday, December 17th, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Myles Byrnes, 416701.
This is a public hearing, and public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I'm going to review and make findings of facts to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. The recommendation is then going to be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing is going to be taken under oath. So, Mr. Byrnes, can you please raise your right hand?
Yes.
You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes, I do.
Thank you. So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that your parole officer has brought against you. I'm going to review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings, but you will have an opportunity to present any relevant testimony or any relevant documents for the case. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the procedure or purpose before we begin?
No, I don't.
Okay, so we are going to go over your rights. The first right is you do have a right to be represented by an attorney at this hearing. I know at the preliminary hearing, the public defender's office stated that you are ineligible to work with them.
Yeah, I don't understand why, because I don't have a job anymore.
Yeah,
So they
I'm
said
not
I didn't
sure.
qualify for it.
Correct. So do
Yeah.
you have the intentions to hire an attorney?
No, I don't.
Okay,
No,
so you're okay
yeah.
with moving forward today without
Yes.
representation?
Yes, I am. Yep.
Okay, all right. So you also have the right to receive written notice of the charge of the violation. Did you receive that written notice?
Yes.
Right. You have the rights to review the evidence against you before the hearing, and you have the rights to submit evidence in support of your case. And in addition, you have the right to call and examine any voluntary witnesses and cross-examine adverse witnesses. Do you understand all these rights, and are you ready to go forward?
Yes.
So we're going to review the charges that the state has brought against you, and that's your parole officer. All right. So for charge number 1, condition of drug testing, the charging officer reported that on April 25th, 2024, you were found in possession of a small alcohol bottle at Connection House, which you confirmed contained another person's urine, clean urine sample. You admitted to Halfway House staff that you had used illicit substances and alcohol, indicating that you had intended to use a urine sample in the bottle to substitute for your own specimen on a toxicology test. On August 6, 2024, you rendered a urine sample for toxicology testing at Connection House, which returned absent of your prescribed medications, amphetamines, indicating that you altered, manipulated, falsified your urine sample. On charge number 2, conditions of drugs, the charging officer reported that on or around April 25th, 2024, you used cocaine and fentanyl. On around October 15th, 2024, you used cocaine. On around October 16th, 2024, you used cocaine. On around October 17th, 2024, you used cocaine. On charge number 3, condition of no consumption of alcohol, the charging officer reported that on and around April 25th, 2024, you consumed alcohol. And for charge number 4, condition of halfway house placement, the charging officer reported that on October 13, 2024, you were assigned out of the Eddy Center halfway house on an approved community pass to attend work. Your pass was issued around 8 a.m. From 8 a.m. to 5:30 p.m. And the only approved location for your pass was for your job site. Halfway house staff contacted your employer who reported that you had not shown for work that day. You were unaccountable in the community for 9.5 hours. Your actions are in violation of your signed halfway house agreement, which states I will only go to location indicated on an approved community path unless changes have been authorized. So I do want to note, though, at your prelim for charge number 1, condition of the drug testing, I did identify it as 2 parts, and a no finding was made for part 2 with the charge date of August 6th, 2024. So that charge was not taken into consideration at today's hearing, okay?
Okay.
The evidence submitted by the state was already identified at the preliminary hearing. So just to confirm again, did you receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, I did. Yep.
Great. So we also did receive a letter of support. I have not marked it as an exhibit. Would you like me to put it on the record as an exhibit for you?
Yes, if you could, yes.
Perfect. So then I am going to identify exhibit 1 for the defense. That's a letter of support from Thomas Linskin.
Thomas Linskins, yeah.
Okay,
Yep.
So that's exhibit 1 from Thomas Linskin. All right. Do you need any additional time to provide any other evidence at this point?
No, that's basically it.
Okay.
Yeah.
All right, then we're gonna move forward. So now it is your time to respond to the parole violation charges against you. However, remember that you have the right to remain silent if you choose to do so. So would you like to make a comment as to the charges?
Yes, I would, yeah. I definitely have learned my lesson since I've been in here. I've put people through pain once again. I play with fire, and I played with fire, and I got burned, and I don't want to get burned again. Like I'm tired of getting putting people that I love in positions where they have to, pick up that jail call and hear the voice of the woman, and I'm tired of putting myself through this pain. Like I've been through this long enough where I finally have a support system with Thomas Linskins. He was my previous guardian. And he's back in my life, and I cherish his friendship because he's the one who is going to look out for me when I get out there, because my mother just moved away. So now I don't have anybody out there except him, but he's my biggest support. But now that I have a support system and I have to get out there for my son's about to be 8 years old. I'm missing out on my family. All because of my actions. And I regret them being selfish enough to put everybody in this position and even have this revocation hearing for my actions. So that's my statement right there.
Yeah, I appreciate it.
Yeah.
Okay, so I'm just going to take a moment and then I'll announce my findings.
Okay.
Okay, so on charge number 1, part 1, I do find that you violated the condition of drug testing, based on evidence provided in support of the charge, exhibit B, D, L, and Q. On charge 2, I find that you violated the condition of drugs based on exhibit B, D, L, N, O, P, V, W, X, Y, AA. On charge number 3, I find that you violated the condition of no consumption of alcoholic beverages based on the evidence in exhibit B, D, L, and P. And on charge number 4, I find that you violated the condition of halfway house placement based on the evidence provided in exhibits B, T, U, and double B. So at this time, that does conclude the fact-finding portion of the hearing. Before I make my recommendation, is there anything additional you'd like to add to your statement?
If I get released, I want to be able to get into any kind of treatment program I can, and better myself, because I know what comes when I get out there. I know what's going to be around. I want to have to build my strength and have more people around me that can look out for me, and I can make sure that I do the right thing. So sponsors, I also kept in contact with through Thomas, through my CCAR coaches while I was in here. So I do have a good like sponsorship men out there for myself. So when I get out, yes, I do need that foundation for myself.
So
any kind of treatment.
It sounds like, correct me, that you've lined it up at this point, so you have.
Yes, everything's already lined up. Yeah, my CCAR coaches know that I'm getting released. Well, so whenever I get released, but they know that I'm in here for for dirty urines, basically. That they know I need help, so they're willing to step up even more for me, which is great. So. I really appreciate their help, but that's basically it for my statement.
Thank you. So I have listened to your testimony today. I've reviewed all the evidence submitted, and based on that, I am going to recommend that your parole be revoked and that you serve an approximate 4-month period of confinement. So that's a re-parole date of February 23rd, 2025. In addition, I'm going to recommend the following conditions: no alcoholic beverages, behavioral management program for domestic violence, no contact with your victim HG, a general no contact with HT or JO, mental health evaluation. I don't know that this was a letter of support. Do you need a halfway house, or are you sponsoring to Thomas?
I need a halfway house, yeah.
Halfway house? Okay.
Yeah.
And then halfway house placement. What is your location choice?
Norwich area.
And what's your second choice?
Middletown. Well, it's kind of the same thing.
Yes.
Yeah, I really don't know. Maybe like Hartford.
Okay.
Yeah.
Okay. So I'm also going to add halfway house placement as my recommended conditions. So those are my findings, and they're going to be forwarded to the board on January 2nd, 2025, and you'll receive a written notice from them shortly after. Okay. The board at that time can lessen my recommendation. They can also let it stand, or they can impose a sanction longer than what I've recommended. If they do want to do a longer sanction, you'll be notified of it as the reasons why, and you'll be called for a hearing to address the reasons why with them yourself.
Okay.
And that's pretty much it. Do you have any questions at this point, Mr. Byrnes?
No, I don't. That's it for me.
All right, so after January 2nd, you'll receive the notice whether or not they adopted the recommendations. And since you're on special parole, that would, whatever date's on that form will be the date, okay?
Okay.
All right, you are all set then. Thank you for talking to me. I appreciate it.
All right,
Have a
appreciate
good
it. Thank
day.
you. You too.
This includes the final revocation hearing for Myles Byrnes. Thank you. Have a good day.
Sorry for the delay. You too.
Hello.
Hey, good afternoon. How you doing?
I'm great. How are you?
Doing well. I had a quick question for you.
Yes.
So I know you guys have a few people to see. We have
Yes.
count time at 12, so I'm trying to figure out how this can best work for you guys. Do we have any clue how long you'll need with each of them, or is it gonna vary?
It's going to vary. I'm not committed to timing, unfortunately. I do want to see, well, I don't know if you care who I want to see. I was thinking Foye first, and then Marrero, and then Hudson and Campbell. I don't know if it
2-6 to 8-8, stand by on that 7, please.
makes it easier to just plan to see Hudson and Campbell at 12:30. Would that be easier for you guys? What's best?
So count usually goes from 12 to 12:30-ish, hopefully. I certainly don't want to hold you guys up either, so I'm trying to schedule where I can work with everybody. So you want to see Foye first. That's what you're shooting for. And who were you thinking after? Marrero?
Marrero, yes.
Okay. And again, there's no time that you think?
So ideally it could take 10-15 minutes with each of them, but some of them go about 20-30 minutes. I can't tell you, unfortunately.
All right, so what I'll do is I'll shoot for bringing the first 2 that you just called down.
Okay.
I'll try to I'm gonna get them down here now, and then we'll just have to take it from there. It just may take a few minutes to get the guys here since we're gonna be on count time.
Okay, all right, yeah,
Okay.
whatever you can do. Yeah, I appreciate it. Thank you.
Okay, so I'll get Foye and Marrero down now.
Perfect, thank you.
Okay, no problem. Yes, ma'am.
Good morning again.
It's still morning. Good morning.
Did you receive the exhibits for Foye?
Yes.
Okay, thank you.
2 of them, correct? 2?
No.
I have a list. I wrote read the list. I have 4. Yeah.
4. Okay.
Yeah, I wrote read list.
Okay,
Yes, I
thank
have
you.
4. Perfect, thank you.
Okay, 66 Ben Marrero. Can you send them the video conference now? Yeah, thank you. Hey, were you able to get him? I mean, if he has to sit down here, he'll sit down here. I should put him on off count. Quick thing though, East Dorm 124, Foye. Got him? All right, send him down video conference now, please. Okay, I got you. Thank you so much. I'm ready. Come on, real quick, just have a second, okay? Yeah, just for a second. Hey, ma'am, quick question. Campbell came down here first. Would you like to see him or do you want him to wait? Foye should be here soon and Marrero should be here soon as well.
So I need to connect with his parole officer, so I'm not ready for him yet.
Okay, no problem.
Yeah, he can wait. Sorry, thank you.
No, it's no problem.
All right, so it's Parole, where she is.
Just know that it's gonna be, it could even be done, how much it's gonna be less. As long as you here on the same page.
I just pray people don't get no time. Thank you so much.
Yes, sir, I got you. I'll call you down in a few.
All right.
I'm gonna be able to scan it. Okay, because I know they got that one they just called. Just, it was just trying to get my sport. He's already out. So, I haven't really come from the storm and Western. They said they sent over them all already. Video conference. I'm gonna come that way, but don't make them go back. Don't tell them to go back. I'm on my way over to you now. Oh. No, okay, thank you. All right, so real quick, when it's one thing, it's another, you know? So we just had a code get called in the facility. So I'm gonna try to go and grab both of these gentlemen myself to try to get this ball rolling for you guys. So I'm not gonna be in here. So if you try to yell out to me, I'm not gonna be in here. Just give me a few minutes. I'm gonna try to make it happen the best I can, okay?
Hearing examiner Trisella.
Hi.
Hi. While we're waiting for Foye, just to let you know, I'm going to be referring to Exhibit G. If you want to get that out now.
Absolutely. I appreciate it.
And I did not receive Exhibit H.
Receive Exhibit H. I didn't either. Correct.
Okay. I did get a copy of it because it's the police report. I may refer to it, but I just want to let you know that it's missing. So I think that's significant. So, okay.
Okay. Got it.
Just wanted to give you the heads up.
Thank you.
You're welcome.
Straight ahead with the leg on the board. Marrero, come on. Marrero, man.
Are you Mr. Foye?
Yes, ma'am.
Perfect. Right.
You can take a seat, sir.
Thank you.
You're welcome. Good morning.
Morning.
So good morning. It's still morning. You just said that to me. Good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Timothy Foye, inmate number 408662. Today's Tuesday, December 17th, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New Haven Correctional Institution, or Correctional Center, I think, actually. Can you please state your full name and DOC inmate number for the record?
Yes, Timothy Joseph Foye. My number is 408662.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti. Can you please identify yourself for the record?
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violates the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Foye, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning the case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for the hearing. So the first is I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify the state's exhibits for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and severity of the allegations. And then at the conclusion of the hearing, I'll inform you of my findings, which will be based on the available evidence. Do you understand? Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. So you do have rights to this hearing, and the first is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, this morning.
Great. You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. You also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're now going to review the charges that the state, your parole officer, is bringing against you. So charge number 1, condition of obedience to the law. The charging officer reported that on November 28, 2024, you caused disruption within the confines of the Sierra Center halfway house. This action occurred after you was accused by Sierra Center staff of throwing a vape and hitting the staff member in the face. You were subsequently arrested and charged with violating Connecticut General Statute 53A-181, breach of peace. The state has submitted the following evidence that had been pre-marked for identification purposes, and that's Exhibit A, the remand to actual custody order, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the notice of parolee rights, Exhibit E, the signed PCS conditions, Exhibit F, the signed halfway house agreement, Exhibit G, the Sierra Center halfway house incident report, Exhibit H, CSP Troop I police report, case number 2400451794, and Exhibit I, the Connecticut Judicial Court lookup court date 12/9/24 for N23N-0257285S. I do want to make a note that Exhibit H, the Connecticut State Police Troop I police report, case number 2400451794, was not included in the packet. So it will not be admitted into evidence. Would you like me to admit it into evidence, Attorney Famiglietti? Oh, you're muted.
No, it's not my client's duty to submit it. I will refer to it. However, I do not wish that it be in evidence.
So I am not admitting it into evidence as it was not submitted in the packet. Attorney Famiglietti, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified for today's purposes?
Yes, I have.
In addition, I did receive evidence submitted by the defense, and that's Exhibit 1, a letter from psychiatrist Bradford Martins, MD, PhD. Exhibit 2, a letter from therapist Daniel J. Varley, LCSW, 2 pages. Exhibit 3, a letter from CCART internship supervisor Edgardo Patron. Exhibit 4, the first program graduate certificate. Do you and your client need any more time to submit additional evidence?
No, we do not.
So we do not have any witnesses today. So now it's the defense's opportunity to respond and make a short statement, call any witnesses, and testify with respect to probable cause and severity of the allegations.
Yes. I would like to challenge probable cause. I don't believe there's sufficient evidence submitted regarding a finding of probable cause as to the obey the law. There is an inaccuracy or an inconsistency in the allegation that the vape hit the staff member in the face. If you review the connection report submitted by the alleged victim herself, and the last sentence of the second to last sentence of the description of the incident on the first paragraph, Mr. Foye then said to staff, "Get the F out of here, you be. You want the effing vape." He then threw the vape at the staff. He never hit her in the face with the vape. She had asked him, it's clear, that he inform him of his chores and give him black trash bags, and he was frustrated. So he threw, allegedly, a vape on the floor. If you look at the police report, which has not been submitted as evidence, you still haven't packed anything. This is from her written statement to the police that was not submitted. Interestingly, why was it not submitted? Then that's when I saw the vape in his hand. I asked to place it on the table in his room. Right after I told him, he said, "You want the effing vape?" Then he threw it in front of me. See attached statement. This is in what was to be purported to be Exhibit H. It is clear. One, we don't have a police report submitted to back up the obey the law charge. So that's absent. So that's insufficient evidence. Second of all, one piece of evidence, the report from the incident report authored by the victim herself said, alleged victim, that he threw the vape at her. The report and her own statement that I have is clear that he threw it in front of me. So I don't believe there's probable cause. I believe there is insufficient evidence to conclude that my client disobeyed the law. As to the seriousness of the allegations, I'd ask you to consider the 4 exhibits as to what the general character of my client is. In 28 years of practice, I can count on one hand the number of clients who have had this much support from their treating staff in 28 years. My client is engaged in treatment. I can read excerpts from there, but most importantly, the legislature requires a finding of sufficient seriousness, not just serious. So we don't just have to find that it is serious enough. There have to be degrees and levels of severity. And so this would have to be sufficiently serious enough to go forward with revocation. My client's been held since November 28th. This is his first violation. He has been at the Sierra Center without incident since January, without any graduated or interventions or sanctions other than one positive use for cocaine on October 21st. And he's been in treatment. He's been tested there. He's thoroughly engaged in treatment. To quote his doctor, Tim has shown incredible dedication, not only to his own personal recovery, but to helping others. He has been consistently and actively engaged in treatment with me, working to improve his mental health and maintain his sobriety. His resilience and perseverance through personal hardship demonstrate the strength of Tim's character. His father, my client, faced significant stress in recent months with the death of his father, but despite that, has been doing famously in treatment. Tim is the ideal patient. He is hardworking, insightful, kind, and genuine. He has adherent to all his medications. It has been a pleasure watching Tim on his journey of growth and recovery. I am confident he possesses the ability to reach any goal he sets. I would hate to see someone who has worked as hard to better himself be prevented from advancing forward in his academic and career pursuits. He is engaged at Gateway and an internship at CCAR. The Exhibit 2 speaks that he is more than just a member of a peer group. He is a mentor, a leader, and a role model. Mr. Foye uses his experiences and his recovery to help others. It is for that reason, for his character, the fact that the statement is consistent, Exhibit G is consistent that he did not hit. He threw this on the ground. I don't believe throwing a pen and swearing at someone, or I don't even believe he threw it at her. He threw it on the ground in frustration. Thank you for your time and consideration. I ask that a no finding be made as to probable cause, and if a finding is made, I'd ask that this be found not sufficiently serious enough to go forward with a violation, as I don't believe further incarceration is necessary or appropriate. Thank you for your time and consideration.
Thank you. I'm just going to take a moment. I'll get back to you with my findings.
Thank you very much.
I'm actually going to just take a quick recess. I'll be right back.
Thank you.
Thank you.
Tim, can you hear me?
Yes.
Okay, she'll be right back. She's just checking. Okay, and one of two things will happen, or one of three things will happen. She'll either find probable cause, okay, and either find it not serious, and then you'd be released today, okay? However, if in fact she finds that it's the probable cause and it's serious, you will still be held until another hearing, okay? But we're hoping that she doesn't make one of those two findings, okay?
Yes. I just want to say thank you for your representation. I appreciate everything you said.
Oh, you're welcome.
Everything you did.
You're welcome. Thank your counselors.
Okay, thank you. So I am gonna make my finding, and I am gonna find probable cause for charge number 1, obedience of the law based on exhibit B, E, G, and I. However, I do find that acts are not serious enough to warrant revocation, and with that, your parole is going to be reinstated, Mr. Foye. The records office at the facility, and your parole officer will be notified of this. And that's all for today.
Actually, yeah, he's still held on a $5,000 bond.
Oh,
So he's going to have to post that bond
correct.
before parole can release him.
Yeah.
So do you have a family member to call, sir, to have that bond posted?
Yes.
So you can call them right now, or actually, what's their telephone number?
Is 860?
Yep.
367?
Yep.
7473.
And once you post that bond, or if you hear that they're going to post the bond, you should call your parole officer, okay, and let them know that you're available to be picked up, okay?
Okay.
Thank you.
Thank you.
This concludes the preliminary hearing for Timothy Foye. All right, good luck, Mr. Foye.
Thank you. I appreciate it.
Good luck, sir.
Thank you. Have a great day.
Everybody, have a good day.
You too.
You
Thank
too.
you.
Thanks.
You'll try to keep calling guys.
Hey, Mr. Marrero.
Hi, how you doing?
I'm great. Can I just be with you in one moment? I'll be right.
Sure.
Thank you.
I'm in your clock. I'm good. Shit. Excuse me.
Okay, good afternoon. I am Parole Officer Chisello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Hector Marrero, inmate number 215029. Today is Tuesday, December 17, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office at New Haven Correctional Institution. Can you please state your full name and inmate number for the record?
Hector Marrero, Marrero, inmate number 215029.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. And this is a revocation hearing, and we're going to go over the purpose of it. So the purpose of the revocation hearing is to determine if you violated the conditions of your release. I'm going to review and make findings of the facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support the violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. The recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing is going to be taken under oath. So, Mr. Marrero, can you please raise your right hand?
I'm looking at it.
You got it, that one. Yeah, thank you. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning the case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yeah.
Perfect. So we're going to. Awesome, thank you. So the procedure for the hearing is as follows. You can put your right hand down.
Okay.
You're good. Thank you. So first, I'm going to read you your rights. Then we're going to go over your parole violation charges that the state your parole officer is bringing against you. I will then review and identify the exhibits filed for the record. The state is not present at today's hearing. However, you will have the opportunity to present any relevant testimony and any relevant documents. After the consideration of all the evidence presented, I will announce my findings. If I find you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights to this hearing, and the first one is that you have a right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you have intentions of hiring an attorney?
No.
Okay, my understanding is that you actually declined to have representation. Is that correct? With the public defender's office?
No.
No. So I know I'm going to say this 3 more times, but as of today, you're ready to move forward without an attorney present.
With an attorney present? No.
You're okay with moving forward, is what I'm saying. Yes.
Yeah, I'm okay with it now.
Okay.
I mean,
So.
Yeah, I don't need no attorney, no public defender.
Okay. All right. So you also have the right to receive a written notice of the charges of your violation. Did you receive the written notice?
Yes, I did.
Perfect. You have the right to review that notice as well as all the evidence that has been brought against you. And you have the right to submit evidence for your case, as well as the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand all these rights?
Yes.
Are you still ready to move forward?
Yeah.
Great. So we're going to review the charges that the state your parole officer is bringing against you and the information underlying each charge.
Uh-huh.
All right, so for Charge number 1, condition of reporting. The charging officer reported that on September 16, 24, you were discharged from Walter Brook Halfway House and instructed via your release directions to report directly Parole Officer Bent at the New Haven District Office. On 9/16/24, you failed to report as instructed. And number 2, on 9/17/24, you made contact with parole staff via your cell phone. You were instructed to report to Parole Officer Bent at the New Haven District Office on September 18, 24 at 9 a.m. And on September 18, 24, you failed to report as instructed. On charge number 2, condition of absconding, the charging officer reported that upon your release from Walter Brook Halfway House on 9/16/24, you have failed to report to the New Haven District Parole Office as instructed by your release direction and parole officer instruction. To date, you have failed to make contact with or report to your supervising officer as stipulated by your conditions of supervision. Your whereabouts in the community remain unknown. The state has also filed the following exhibits that have been pre-marked for identification purposes, and that's Exhibit A, the Connecticut Conditions of Parole, Exhibit B, the Connecticut Board of Parole Remand to Custody Order, Exhibit C, the Notice of Parole Violation, Parolee Rights, Exhibit D, the Parole Violation Report, Exhibit E, the Offender Misconducts, Exhibit F, the various PVR top Exhibits A through D, Exhibit G, the Decision Information Summary. In addition to those documents, the state has filed an addendum to the Parole Violation Report on November 4th, 2024, and that's also admitted into evidence, and it reads as follows. In reference to the Parole Violation Report submitted by P.O. Bent regarding Marrero, Hector, the following applies. On October 15, 2024, the Board of Parole issued a warrant based on the report declaring the offender an absconder from special parole supervision. On October 17, 2024, the case was transferred to FIU for investigation. On November 2nd, 2024, Marrero was located and detained by New Haven Police on his parole warrant. Marrero was taken into custody by FIU and transferred to Haven Correctional Center, where a remand to custody order was lodged with AP staff, and he was served his notice of parole violation and provided his parolee rights. Parole violation notice, parolee rights, and remand were scanned into evidence in case notes on 11/4/2024. Mr. Marrero, did you receive the notice of parole violation, the parole violation report, and all the other documents that have been marked for identification purposes?
Yes, I received everything. I received the mail, and then I received the paperwork when they brought me here.
Yeah.
And yeah, that's what I'm saying. I got the packet in here, and then when they brought me in, they gave me some papers, so I got all of that.
Yeah, okay,
Yeah, and
great.
I went through it, and
You reviewed
I didn't
it?
understand it. I didn't understand it because I don't read too good.
Okay.
But some of the guys helped me out. They read it for me, and I understand a little bit about it.
So you were able to at least get the logistics of it, yeah? Perfect. Okay, I have not received any exhibits from you. Is that accurate? Have you submitted anything for evidence?
No,
Okay.
exactly.
Do you need more time?
I wasn't taking my medication.
Hold on, don't get to that yet.
Okay.
Or we're not there yet. I just want to see if you want to submit any evidence. No
Oh,
evidence?
no.
Okay. Yeah, we'll get to that part, okay? So, so at this time, it is your opportunity to respond to the parole violation charge against you, but remember that you do have the right to remain silent if you choose to do so. At this time, it is your opportunity to make a comment, call any witnesses, and testify regarding your case. Okay, now for the comment. If you choose to do so, you do have the right to remain silent, though. So it's up to you. You can talk towards the charges.
I want to make sure.
I just wanted you to know you're right. You also have the right to remain silent. So I just want you to be aware of it, okay?
Yeah. So let me know when I'm ready. I mean,
It's your time. Go ahead.
Okay. Yeah, I know. When I came out the halfway house, yeah, I just had a lot of things to do, and I'd be forgetting things. And I did got in contact with Officer Smith, that he was my parole officer. I called him. And then me busy again, and just forgot. And then I wasn't taking my medication. My HIV medication, my mental health medication. Because I'd be forgetting things, and I wasn't taking my medication, and that's what caused all this boom.
Okay.
And I'm still there at 70 Fairmont Avenue. But David said that y'all went there, but I hardly be there because I live by myself, so I was just always out there working on cars, whatever, but not doing for the dirty or no drugs, no nothing. I wasn't in that no more. So, you know, I just like, I know I did a mistake and now reporting. It won't happen again. This is a lesson that I learned.
Okay, thank you. I do appreciate your comment. So I'm just gonna take a moment. I'll let you know my findings.
Okay.
Okay, so on charge number 1, I do find that you violated the condition of reporting based on the evidence submitted, which was Exhibit A, Exhibit B, and Exhibit E. And on charge number 2, I also find that you violated the condition of absconder based on Exhibit A and Exhibit D. So that does conclude the fact-finding portion of the hearing. I have listened to your statement already. At this point, it is an opportunity for you to speak about your background, the violation, your history, if you choose to do so. Again, you have the right to remain silent, but I have heard what you said already. So do you have any additional comments to make? So I have listened to the testimony and I reviewed the evidence submitted, and based on that, I am going to revoke your parole, and I am going to recommend that you serve an approximate 4-month period of confinement as a sanction. So that's with a re-parole date of March 2nd, 2025, okay? With that recommendation, I'm also going to recommend the following conditions: no alcoholic beverage consumption, no contact with your victim PW and LA, no mental health treatment. And you mentioned a house. Do you need a halfway house or do you have a sponsor?
No, I got my own apartment.
You have your own apartment?
Yeah, 70 Fairmont Avenue.
70 Fairmont Avenue.
Yeah.
Any apartment?
Apartment 105A.
105A. And what city? What town?
New Haven.
Haven? Okay, for any reason, I'm also just going to add a halfway house stipulation in case if something happens, whatever is the case. But otherwise, I'm just gonna make note to Parole and Community Services of your own apartment, okay?
Okay.
But I am just gonna add the stipulation for backup. So my findings and recommendations are gonna be forwarded to the board on January 2nd, 2025, and you'll receive an official written decision from the board shortly after that. The board at that hearing can lessen my recommendation. They can also let my recommended sanction stand, or they can provide a sanction longer than what I've recommended. If they do choose to impose a sanction longer than what I've recommended, you'll be notified of that and the reasons behind it, and you'll be asked to appear for the hearing to answer to their questions, concerns, stuff like that, okay? Do you have any questions for me right now, Mr. Marrero?
No. So that means I'm gonna have to stay here till March?
March. That's my recommendation to them. January 2nd, they'll make the final decision and you'll be notified within a week or so after that, okay?
Oh, January 2nd.
So January 2nd, I'm recommending the March date. They can accept that date. The board decides, the three people on the panel, so they can accept that March date. They can lower it if they want to, or they can increase it if they choose to. So as of today, that is my recommendation going to them. But after that January 2nd date, you'll get everything in the mail explaining exactly the date, the decision, and what the outcome was, okay?
Then I go get released or whatever.
Correct. It'll tell you the date of your release, and you're on special parole, correct?
Yeah.
Yeah, so whatever date that one is, that'll be the date of your release, whatever's on the document after January 2nd, okay? All right, you're all set. Thank you for speaking with me, Mr. Marrero. I appreciate it.
Yep, you're welcome.
Have a great day.
So I'll receive a letter, a mail?
You'll get a few things in the mail, correct? Definitely about a week or so after January 2nd, though, okay?
Okay.
All right, great. Thank you.
All right,
Take
thank
care,
you.
Mr. Marrero.
Yeah.
This concludes the final revocation for Hector Marrero.
All right, who's next up to bat?
I'm good with whoever, so, is there someone at the door?
Yeah, I got your last two guys already sitting here waiting.
All right, I'll take Hudson first.
Hudson,
I just have to call the PO.
no problem.
You should have the PO on. Yeah.
All right, Mr. Hudson, I'll be right with you. I just have to call Officer Desena, okay?
So boys on the way back, I'm getting them.
Officer Desena, are you with us? Officer Desena, I think to unmute it's *6.
Hello.
Hi, thank you. All right,
Hi.
we're ready to get started. So I am Parole. This is Mr. Hudson.
Oh, okay. I thought Campbell was first. Okay.
No, yeah. Do you want me to have them swap? Is this okay?
No, that's fine. I just had Campbell's stuff in front of me, but let me just log on and get Hudson's stuff then. If I need to read the charges again, or
Yeah, you will. So yeah, just take a moment. It'll take a second for us to get there.
okay.
All right, perfect. So I am Parole Officer Chisella. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Tyrelle Hudson, inmate number 398178. Today is Tuesday, December 17, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New Haven Correctional Center. Can you please say your full name and DOC inmate number for the record?
Tyrelle Hudson, inmate number 398178.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. And present this afternoon is Parole Officer Desena. Officer Desena, can you please identify yourself for the record?
Yep. Parole Officer Jennifer Desena.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Hudson and Officer Desena, can you please raise your right hands? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
Yes.
Yeah.
Thank you.
Yeah.
So first I'm going to read you your rights, and then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. And then we'll review and identify the exhibits filed for the record. The state will then have the opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. If I find that you violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you'll have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights at this hearing, and I'm going to review them with you now. The first is you have the right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney can represent you at this hearing?
Yes.
Do you have intentions of hiring an attorney or
No.
requesting? So you're okay to moving forward without representation?
Yes.
You also have the right to receive written notice of the charges of violations. Did you receive the written notice?
Yes.
You also have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. In addition, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. You understand these rights, and are you ready to move forward?
Yes.
Great. So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Desena, can you please read the charges you have brought against Mr. Hudson?
Yep, 1 second. Case notes is a little slow.
It is.
Yeah, it's loading right now. I apologize. All right, here we go. Okay. All right. Release direction, GPS, November 13, 2000. Oh, wait, I'm sorry. I'm on the wrong one. I apologize.
That's what I had.
Wait 1 second.
Okay.
Okay. All right, it was on the right one. I just wanted to make sure. On November 13, 2023, you signed a GPS agreement form. Since your release of community on February 21st, 2024, you repeatedly violated the GPS agreement form and this parole officer's instructions by violating your GPS curfew and failing to charge your GPS as instructed. Release direction E, drug testing. On October 18, 2024, you refused an alcohol breathalyzer when parole staff attempted to conduct one on you. Additional conditions behavioral management program. And August 8, 2024, you were unsuccessfully discharged from DV due to having multiple unexcused absences. You also failed to attend DV on October 3rd, 2024 and October 10, 2024. General no contact with on March 31st, 2024, you had contact with your victim and had to be referred back to DV due to the unauthorized contact.
Thank you. And the evidence submitted by the state was already identified and marked at the preliminary hearing, so they all still remain the same. One more time, Mr. Hudson, did you receive the notice of parole violation, the parole violation reports, and all the other documents that have been identified?
Yes.
I have not received any documents from you for exhibits or evidence. Is that correct?
Yes.
Do you need any time to submit any evidence at this point?
No.
So today we do not have any witnesses. So at this time, it is the state's opportunity to call in witnesses, present evidence, and speak to any of the evidence submitted. So Desena, do you have any comments, statements to make, testimony to provide about the charges?
Hi. No, I explained stuff in the prelim hearing in regards to, you know, his constant GPS violations and where I continuously worked with him in regards to his behavior that I had to issue a misconduct for and had to increase his supervision, send him to CBT, change his curfew, change him to maximum supervision. So I exhausted all of my, you know, tools in regards to trying to work with him and supervise him out in the community until subsequently he was remanded.
And now it's your opportunity, Mr. Hudson, to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. So at this time, would you like to testify regarding your case?
I would just like to say that I know I made mistakes with my GPS bracelet and my curfew, but at the same time, I was completing the groups that they told me to go to. I finished and completed CBT. I completed DV completely once. I was still in DV, actively going. I missed 2 groups, but I wasn't kicked from DV group. I just want to say I was doing what I could. I was doing what I was supposed to. I just had little bumps in the road. That's all it was. I know I'm not a threat to society, and I just want to be home for my family for the holidays. That's it.
Thank you. Just take a moment. I'll get back to you with my findings. So on charge number 1, I found you violated the condition of GPS based on the evidence provided, which is exhibit B, D, E, H, K, and L. On charge number 2, I found that you violated the condition of drug testing based on the evidence provided in support of the charge, which is exhibit B, D, and N. On charge number 3, I found that you violated the condition of behavioral management program based on the evidence provided in exhibit B, D, F, and G. And on charge number 4, I found that you violated the condition of a general no contact with based on the evidence provided in exhibits B, D, L, and F. So that does conclude the fact-finding portion of this hearing. Before I do make my recommendation, the state will have an opportunity to speak to your background and history. And after the state, you will have the same opportunity. So Officer Desena, do you have any additional comments to make about Mr. Hudson's background and history?
Yeah, so I've supervised him and so did other parole officers in the past. Like I added to my evidence in the revocation summary and previous parole violations. You know, he did complete CBT when I was supervising him and when I referred him due to the constant misconduct he was receiving. However, he completed CBT and still continued to disregard his GPS curfew and his shutdowns and so forth. He's had 6 previous parole violations during his current special parole term for various reasons, victim contact arrest and non-compliant behavior. So there's been multiple attempts to try and work with him out in the community, and this being his 6th time violating. So we've tried to work with Mr. Hudson, and tried to push him to obtain a full-time job, and hence the reason that's why he was on the bracelet for so long. So that's why Paroles recommending that he just remain incarcerated until his EOS. Thank you.
Thank you. Mr. Hudson, would you like to make a statement regarding the violation background and the history? Anything additional from your previous statement?
Yeah, I would just like to say that I've had work. I've worked. I've stayed out of trouble. I haven't had no police contact. I was home for about 18 months. My curfew violation was maybe the biggest thing I had going on. I don't have a victim in any of my cases. I don't have no court cases. I just want to go home and do what I have to do. I only have until February until I'm done with parole. I've been on parole for a long 8 years. I mean, everybody makes mistakes. Nobody's perfect. But I just feel like I deserve a chance to get it right for the last little couple weeks or months that I do have left on parole. Just to be there with my family. I was in court for my son. Taking care of my kids, trying to get custody of one of them. I just had a lot going on. That's all it was. I just want to get back home so that I can do what I have to do. Take care of my kids.
Thank you. So I have listened to the testimony today and have reviewed all the evidence provided. Based on that, I am recommending that your parole be revoked and that you serve an approximate 7-month sanction, which is a no new re-parole date, as your special parole does end on February 16, 2025. So in the event that the board decides to lessen my recommendation, I am going to recommend the following conditions: no alcoholic beverage consumption, behavioral management program for domestic violence, no contact with your co-defendants, Tyshawn Snow and Justice Hilton, no contact with your victim, MG, a general no contact with SL, halfway house placement, and no operation of a motor vehicle without your parole officer's permission. So my findings are and recommendations are going to go to the board on January 2nd, 2025, and you'll receive notice within the week or so after that of the final decision. At that hearing, the board can just lessen my recommendation or they can let it stand. Like I said, you will get notified of the decision of that when the time comes, but there's no way to go beyond the February date, which is what I'm recommending, February 16, 2025. So this does conclude the revocation hearing. Do you have any questions right now, Mr. Hudson?
No.
And you are all set. I do appreciate you talking to me today. And this concludes the final revocation hearing for Tyrelle Hudson, inmate number 398178. All right, you are all set, Mr. Hudson. Thank you. Mr. Campbell, how are you?
Doing all right.
Good. Officer Desena, are you ready to start?
Yep, I'm ready.
Perfect. All right. So good afternoon. I'm Parole Officer Tyrelle. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Christopher Campbell, inmate number 352722. Today is Tuesday, December 17th, 2024. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Christopher Jerron Campbell, inmate number 352722.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this afternoon is Parole Officer Desena. Can you please identify yourself for the record?
Yes, Parole Officer Jennifer Desena, Waterbury Parole.
Name right one day. This is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe that you committed an act that violated the conditions for your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions for your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath, so can you both please raise your right hands? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Thank you.
Yes.
Thank you. So we're going to go over the purpose and procedure right now. So first, as I will read you your rights, and then we're going to review the parole violation charges that the state your parole officer is bringing against you. Then we will review and identify the exhibits filed for the record. The state will have the opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you do have important rights to this hearing, and I'm going to go over them with you now. The first is you have the right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney could represent you at today's hearing?
Yes.
Okay, and do you intend to seek counsel for this hearing?
No, ma'am.
So you're okay with moving forward today without any legal representation?
Yes, ma'am.
So then you also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes, ma'am.
You also have the right to submit evidence in support of, you have the right to review the evidence that has come in against you for this hearing. And you also have the right to submit evidence in support of your case. You also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am.
So we'll now review the charges that the state has brought against you and the information underlying each charge. Officer Desena, can you please read under charge 1, GPS, the violation details?
Yeah. Yes. Release direction, GPS. When you're released to supervision, you sign a GPS agreement form. You have violated this agreement multiple times. On 6/27/2024 from 1:04 a.m. to 11:07 a.m. You had GPS shut down due to failing to charge your GPS for 2 hours as instructed. On 7/26/24 from 8:30 p.m. to 7/27/24, 6:14 a.m. You had a GPS shut down due to failing to charge your GPS for 2 hours as instructed. On 7/27/24 from 10:39 to 11:30 p.m. you had a GPS shut down due to failing charging your GPS for 2 hours as instructed. On 8/7/2024, you were not home for your GPS curfew of 11 p.m. and stayed out all night at a motel. On November 23rd, 2024, from 12:06 p.m. to 1:30 p.m., you had GPS shut down due to failing to charge your GPS for 2 hours instructed. On 11/24/2024, from 9:52 p.m. to 10:18 p.m., you had a GPS shut down due to failing to charge your GPS for 2 hours as instructed. On November 23rd, 2024, and November 26th, 2024, you tampered with your GPS by shielding the unit, an effort to block this PO from seeing where your whereabouts were, and subsequently violating your GPS curfew. You're in violation of the GPS treatment agreement form. Additional condition behavioral management program. On November 5th, 2024, you were unsuccessfully discharged from the Explore DV program due to having unexcused absences on 7/29/2024, 10/1/2024, 10/29/2024, and November 5th, 2024.
Thank you. The state has also filed the following exhibits that have been pre-marked for identification purposes. Can you please read the evidence that you have submitted?
Yes. Do you want me to say Exhibit A, remand to custody, keep on saying exhibit, or just read off the evidence?
Oh, no. Can you say Exhibit A? Sorry.
Oh, no worries. Exhibit A, remand to custody. Exhibit B, parole conditions. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, GPS agreement form. Exhibit F, GPS event history showing shielding for 11/23/2024 to 11/25/2024. Exhibit G, Explore discharge letter. Exhibit H, previous PVR. Exhibit I, previous Board of Parole revocation summary. Exhibit J, GPS event history for violation of 6/27/24 from 1:04 a.m. to 11:07 a.m. Exhibit K, GPS event history for violation on July 26, 2024 from 8:38 p.m. to 7/27/2024, 6:14 a.m. Exhibit L, GPS event history for violation on 7/27/2024 from 10:39 p.m. to 11:30 p.m. Exhibit M, GPS event history for violation on 8/7/2024. Exhibit N, GPS event history for violation on November 23rd, 2024 from 12:06 p.m. to 1:30 p.m. Exhibit O, GPS event history for violation on November 24th, 2024 from 9:52 p.m. to 10:18 p.m. Exhibit P, GPS liaison email confirming shielding. And Exhibit Q, GPS event history showing shielding for November 26, 2024.
Thank you. Mr. Campbell, did you receive the notice of parole violation, the parole violation reports, and all the other documents that have been identified for this hearing?
Yes, ma'am.
I have not received any evidence from you. Is that accurate?
No, ma'am. I have, the evidence I have, like me speaking up, but like as far as like paperwork and stuff, yes, they was rushing me on, like kind of in a rush to come out here, but I got everything up here that I have to say.
Okay, so we don't need to continue this for you to submit any documents?
No, ma'am.
So now it is the time that the state will have the opportunity to make a short statement, calling witnesses and testify with respect to probable cause and severity of the allegations. So Desena,
Yes.
would you like to make any statements or comments towards probable cause for the charges? Yeah.
Yes. You know, Mr. Campbell was released back out in the community after the board reinstated him, finding cause from a previous probable cause, but not serious enough to continue to reincarcerate him. And, you know, he came back out to supervision after unsuccessful discharges from domestic violence, substance use, where he tested positive. He was remanded back to custody due to all those factors I just stated. You know, we've tried to work with him, continue to work with him by giving him sanctions with, you know, GPS curfew, you know, referring him back to DV. But due to the constant disregard, you know, for the parole conditions, it was determined that we would, you know, technically violate him due to be unsuccessful discharge from Explore again, due to it being stipulated by the Board of Parole. He then subsequently, I noticed the shielding on the GPS, which was confirmed by the company that has our GPS, that he was covering the device, in which he subsequently admitted to me on the way back to New Haven, CC, that he did in fact cover his device with cheap aluminum foil. So, you know, due to the charge that he's on for a mandatory GPS his entire time of supervision due to the Berg 1 and carrying a dangerous weapon, you know, by him covering the device, we couldn't confirm his whereabouts at all during that time when he subsequently was covering his device those few times that was showed in my evidence. So that's subsequently, that's the reason why he was remanded back to custody on technical violation. And that's why the state is recommending at least a minimum of 6 months.
Thank you. Thank you. Mr. Campbell, now is your opportunity to respond to the parole violation charges against you, but I want you to keep in mind that you do have the right to remain silent if you choose to do so. So at this point, would you like to make a statement?
Yes, ma'am.
Yes. Okay.
Say, I couldn't hear you, sorry.
Regarding the charges, so your statements, just make sure that they're related to the charges, okay?
Yes. First and foremost, I take full responsibility. I knew what I was doing when I covered my bracelet. When I missed my third day of the class, I kept it real where I told her I honestly overslept. I didn't give her no excuse, I just totally forgot. Remind you, I'm 33, living on my own for the first time. Got my second job at 33 years old. So all this is still new to me, and that's no excuse. But the thing that I disagree, one of the things I disagree about, my curfew was never 11 o'clock, never 11 o'clock. And every time I stayed out at a motel, she knows what's going on with my apartment. I got every text message in my phone when I let Desena know I was staying at the hotel. I got every message. And I got, my phone is in my pocket. I got every single last message. She gave me the okay every time. You bring up this one time, you should have brought up all the other 20 times I stayed at the motel. All the other 13 times I stayed at the motel. And like I said, she knows what's going on with my apartment with electricity. I have every message from day one. And she recommended me 6 months. But she's sending me mixed signals because you would send me a text message, oh, I'm so proud of you, Mr. Campbell. Keep up the good work. But you skipping protocol. What about the 45 to 60 days to 90 days to 120 days? You just went straight for the kill and asked for 6 months. But you so proud of me for doing so good. I'm from Hartford. I could be in Hartford for a week straight. When I tell you this lady won't ask me where I've been, mind you, my case, everything's in Hartford. The victim, she won't ask me, Campbell, where you been in Hartford? Have you been around the victim? She won't ask me none of that. She'll text me and ask me why I'm on this street in Waterbury. Respectfully, I could be anywhere in Waterbury because my stipulations don't have nothing to do with Waterbury at all. I just live in Waterbury. She won't ask me nothing about Hartford at all. When she do home visits, I meet her in the street. She don't even know how the inside of my apartment look. For what it's worth, I could have all type of weapons in my house because I'm on. Because
I'm gonna refocus you though, because like I said, anything you say can be used against you.
Yes.
But I just want you to focus on the actual charges. So I did hear you say that she was aware of the hotel situations.
Yes.
So focus on
very
what the
aware.
charges against her. Yeah, and I heard about the third day at the Explorer program, you overslept. So you're saying she was aware of that? I don't know if I missed that part.
No, I told her like there wasn't no excuse. Like when she asked me why I missed it, I just said, yo, I overslept. I just got diagnosed with anxiety. I'll be knocked out half the time. I smoke my little joint. I'll be knocked out. And I kept it real with her. I didn't give her no BS excuse. I done had more unsuccessful discharge in the halfway house versus me being home. I done had four unsuccessful discharge when I was in the halfway house. I only got 2 this time. I got my son back in my life. He got autism. My mother just started letting me get him every other week. Got a job. Like on paper, it looked bad. It honestly do. I have been home for 1 year and 6 months. Never had one dirty. Never had no police contact at all. And when we talked about my punishment for me missing the DV class, I literally texted like Desena, what is my punishment going to be? I came back to jail for this the first time. I said, what is my punishment going to be? She said, I'm going to let you know in a few days. She hit me back in a few days and said, your curfew's going to be 9 o'clock and you got to report every 2 weeks. To be honest, from being on 11:30 for 1 year and 6 months, just to go back to 9 o'clock, I couldn't, that wasn't for me. And that's when I decided to do that dumb, take it into my own and cover my bracelet. Other than that, I'm doing perfectly fine. Like, I'm not a threat to nobody. I'm not a threat to myself. I'm not a harm to the community at all. And for her to recommend me the TOP program, from what I know, the TOP program is for people who catch dirties and stuff like, I haven't caught not one dirty. And you recommended me 6 months, the TOP program, and then to come home to the halfway house and you know I gotta pay my own rent. It's like I don't know what her ulterior motive with me. Like, she told me around the time when I first met her, if you work for 4 months, I'll take you off the bracelet. I worked 4 months, and when it was time for me to get off my bracelet the day before my birthday, April 17th, she told me she couldn't take me off the bracelet because she didn't know I was on she didn't know I was on parole for burglary. And I told her, how you not know your own client wasn't on parole for burglary? You should know everything about me before I come home. So for her to say that, I just felt like that was like weird because you know everything about me before I even came home. So that was her reason to keep me on the bracelet. I ended up quitting that job, got a new job. I've been working. This one is a tent job. It's at warehouses in Waterbury. It's called Tent Bear. I've been doing good. She told me to get another job. It took me a while to get another job, but I got another job though. She had asked me how I'm paying my rent. I got a job. You're not asking me about nothing else. Like the question that she should be asking me when I go see her, she don't ask me at all. You know I got a job, so that's how I'm paying my rent. Ask me serious questions about the victim, stuff like that. If I'm around with guns or stuff, never ask me that. Don't never ask me those type of questions. So with that being said, she skipped the whole protocol, like I said, from 45, 60. I recommend 45 to 90 days, to be honest. 6 months is...
We're not at that part yet anyway. Yeah, we're in the beginning stages.
6 months is crazy. It's like you want me to lose my apartment. I'm already a month behind, so that's 1,100 already. 6 months? You want me to come home, go to the happy house, then run around like a chicken with my head cut off, trying to get passes from the happy house to go get my stuff from my apartment. It's like she's trying to make it harder for me, like when I come home. But you're so proud of me though. And I'm not even from Waterbury. And I'm doing a damn good job, excuse my language.
Yeah. Okay, so I do hear you, Mr. Campbell. I do understand your frustration. Officer Desena, do you have any additional comments to make? Desena, I'll get your name right.
Yeah, just the additional comments where I did work diligently with him. You know, he had the Board of Parole stipulated him to participate in complete domestic violence. You know, we allowed him to get an unsuccessful discharge multiple times. and then he came back out and then got an unsuccessful discharge. I even worked with him in regards to, due to him having trouble get to domestic violence. That's the reason why he would say he would miss groups is transportation. But then when he came back this time, I said, you know what? We're going to have him do it virtual on the phone. So we even had him do virtual. So the likelihood of getting unsuccessful discharge again would be, you know, slim, but then he got unsuccessful discharge again, even when we pulled some strings to get him to virtual. You know, he had that apartment that was being paid through Project Longevity. The year was up in regards for them to pay the rent. When it was time now for him to sign the lease, he wasn't working full time. He stated that he did obtain a recent job, probably about 3 weeks before we technically violated him. And he never provided me with any pay stubs, and he might have went to work maybe twice. So it wasn't a legitimate full-time job when the time was to come when he got violated. And then his apartment, he was just signing the lease again. And the only reason why, you know, parole is concerned is that he didn't have a full-time job, and then he was going to sign another lease to stay in that apartment. So I just want to clarify those things in regards to the employment, the domestic violence, where we did work with him in regards to getting him virtual. And then also, yes, that's what I do with when I supervise. You know, I was proud of him when he would make, you know, good strides in regards to his curfew and, you know, doing well, because he was doing well. But subsequently, after getting unsuccessful discharge from DB again, covering his GPS, where in fact he admitted to me, you know, that's were the reasons where we did decide to technically violate Mr. Campbell.
Thank you. Mr.
That's
Campbell.
it. Thank you.
That's okay. Go ahead, Mr. Campbell.
And the virtual, he was against me doing that. I found out I could do virtual. My first violation from dudes from inside here, they never recommended me virtual. I brought the virtual up to them. She was still going against me not doing virtual. So that's a lie. That's the God's honest truth. She was against me doing virtual. To be honest, she didn't want me to do virtual. I thought that I could. I thought that I could do that.
You got into it though, correct? You got into virtual? You did get into the virtual?
Yeah, because of me, not because they recommended it. I found out from behind the wall I can do virtual. She was so against me not doing virtual. So that's a lie, a straight up lie. My lease was up October. I've been paying my rent since then. She bringing, basically, in the report, she want me to get punished for before. She clearly says that I want him to get penalized because he didn't get penalized the first time. That's like double jeopardy. I did one time, I got punished. You didn't recommend no jail time, so of course I didn't get no jail time because you didn't recommend it. You recommended jail time this time, but when I asked you, when we was one-on-one, you told me, no, Mr. Campbell, I didn't recommend any jail time. You'll be home in no time. Her exact words. I'm not nobody for you to lie to. I'm the parolee. You the parole officer. Why are you lying to me? And that's that. But my lease was up in October, and I've been doing a good job. And she never asked me for pay stubs. The day I told her I got that job, I gave her my boss number. I gave him his name and his phone number. I said, any questions you got, ask him. She never not told me one time, bring any pay stubs to your next reporting date. Never. Never.
Thank you. I really do appreciate the comments and testimony. Sounds like a lot was going on.
I'm sorry.
That's okay.
And when I asked her for another parole officer, she kind of talked me out of not following through with the paperwork. She was like, "Oh, you can get a new parole officer, but they're not going to be like me."
Okay. All right, Mr. Campbell. Yeah, it sounds like you have a lot going on. Yeah, you do. I don't want you to keep going. It's recorded everywhere, and everybody across the world is listening. So yeah, I'm gonna, unless you have anything additional to say specific to the GPS charge and behavioral management program, I'm gonna just review the evidence and give you my finding. Do you have anything specific to the charges?
No, I just submit to the shield and the bracelet. That was the only thing I mentioned. That I knew what I was doing. I knew that was wrong. Okay. And that's it.
Thank you. So I'm just going to take a moment and I will let you know my findings. So I'm going to make a finding of probable cause for charge number 1, condition of GPS, based on the evidence submitted, which is exhibits B, D, E, F, J, K, L, M, O, P, and Q. And for charge number 2, condition of behavioral management program, I'm also going to make a finding of probable cause, which is states exhibits B, with the support of states exhibits B, D, and G. So at this time, I am going to find that the acts are serious enough to warrant revocation, and I have determined that you should be detained while you await your revocation hearing. So the facility records department will be notified this, and Officer Desena is here to be notified as well. Your revocation hearing will be scheduled within 60 business days, and it will either be myself or another hearing examiner who will review the case and determine if you did violate the conditions of your parole. And if so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and any sanction that should be imposed. Do you have any questions today, Mr. Campbell?
No, so within 60 days, that's when I'll find out when I'll be able to go back out?
You'll have a revocation hearing, so you'll kind of do this all again, where you can state more of your situation, which is where that information is going to be relevant, okay?
Yes.
And you'll be given a recommendation on that date, and then it will go to a board. If it's found, a finding's found, it'll move forward. If not, things can happen at that date, but that date's more for like the meat and potatoes, like you'll be able to give us more of your understanding.
Yes.
Okay. So this does conclude the preliminary hearing, and I'm going to go off the record, okay?
Okay.
Thank you so much. You're all set, Mr. Campbell. Take care.
All right.
Thank you, officer.
Thank you. Good day.
Thank you. Have a good day.
You too.